Good morning to everybody, and thank you very much. Thank you to the organizers. Thank you also to Ilse for inviting me to speak to you here today. It is indeed very nice to be able to speak about the Brussels I recast again, and especially its scope, because it changed. So when I wrote my PhD, I said, okay, there are 4 pillars that we have to use, but you'll see now we now have 5.5 pillars. So it is indeed time to relook at these issues. So I've divided the presentation into 4 parts. First, the geographic scope, by which I mean very simply in which countries does the regulation apply, in which countries is it law. The second, the temporal scope, when, for which actions do we apply it. And then third, the material scope. This gets a little bit more difficult already. And then my favorite part, of course, the personal scope, meaning to which parties do we apply it? Okay, so even if we are in the geographic scope, we are, for instance, in Belgium, but we have in front of us a party from China and one from the US, or one from France and one from Turkey. Do we apply it or not? That's what I mean by personal scope, depending on the people in front of us. Okay. So let's start with the geographic scope. Of course, it's EU legislation, so of course it applies in EU member states. We also know that for this particular area of EU law, namely judicial cooperation in civil matters, 3 member states have a specific position. They are Ireland, the United Kingdom, and Denmark. Ireland and the United Kingdom have negotiated for themselves the possibility to be fence-sitters, really, all right? So every time there's legislation on civil justice, criminal justice, asylum, they can say, okay, we're joining or we're not joining. For Brussels I, from the very start, they said, we're joining, okay? You can find this information always in the regulation towards the end of the preamble. Right, the very last recitals are about this geographic scope. And there they will always tell you, all right, Ireland and the United Kingdom have opted in or they've opted out. The problem is that they can also opt in at a later stage. So in other words, if it says in the recitals that they haven't opted in, then you must still go and check whether they haven't opted in later. Fortunately for Brussels I, we don't have that problem because they opted in from the very start. So that's clear. Then, Denmark, we also have a specific recital for them. And they are not bound. Okay, they're not fence-sitters. They had the opportunity to get that specific dispensation of being able to opt in or opt out, but they have decided not to take up that possibility. So they're always outside of these regulations. However, Brussels I is quite useful. So they did want to be bound by Brussels I, also because they had this whole heritage of being part of the Brussels Convention before the regulation. So they then concluded an agreement with the EU. So this is an agreement between the EU on the one hand and Denmark on the other hand, saying that they will apply the Brussels I regulation. They will apply its rules. That agreement, I've given you the reference because there was the old one that was for the Brussels I, and then they had the opportunity to just notify the Commission that they will also be applying the recast. Okay, so that's then the notification. The agreement itself is quite technical. It just says, okay, we're going to apply these rules, and it then also grants jurisdiction to the European Court of Justice for interpreting the regulation, because of course interpreting the regulation itself is EU law, so the basis for the EU Court of Justice's jurisdiction is in the treaty itself. But with respect to Denmark, there's a specific agreement arranging that. The whole issue of posing questions to the court and who and how and what will all be discussed tomorrow morning. Right. So then talking about the geographic scope, we must always remember the Lugano Convention. That convention is still parallel to the first Brussels I regulation. So that's still in its 2007 version. It applies to all EU member states plus Iceland, Norway and Switzerland. So the idea is really that the same jurisdiction rules, very similar jurisdiction rules, are extended to these states. Now within the EU, Brussels I obviously takes precedence. Okay? But if one of the parties is from one of these states, then we'll have to also look at the Lugano Convention. So what we're going to do is we're going to see what's the scope of the Brussels I regulation. But then before going on to say, okay, now we can rely on national law, we first have to go and look, but isn't the Lugano Convention maybe applicable to this particular case? Right. That brings us to the temporal scope. The new regulation applies to proceedings instituted on or after 10 January of last year. Okay, what does instituting proceedings mean? It means either the service of the documents or lodging with the court. Okay, when we institute proceedings, that is an issue that is regulated in Article 32. That article also applies for parallel proceedings, because sometimes we need to know, well, which court was first. Okay, so what is the date of instituting your proceedings? And here, the regulation gives us two possibilities, because in national laws, the first step you take in procedures can be different. In some national legal systems, like in Belgium, your first step is the service of documents. Okay, you'll first serve your documents, and then you'll go and make sure that your case is on the court's roll. In other cases, in other countries, you will first lodge your case with the court, and then only serve proceedings. So you have to go then and look in national law which of those two things happen first, and that then is the date of instituting your proceedings. If that is on or after 10 January 2015, you're going to use the Brussels I bis or recast regulation, or Brussels I-A, it's also sometimes called, to determine your jurisdiction. Okay, so that's quite clear. However, for recognition and enforcement, we need to be extra careful, because here we also have to look at the date of the institution of the proceedings. Okay, so in other words, if the proceedings were instituted before 10 January 2015, the recognition and enforcement will still happen under the Brussels I regulation, because Brussels I bis or Brussels I recast has abolished exequatur. Now, the abolition of exequatur only applies to cases that actually fall under this regulation. Okay, so if you're asked to enforce proceedings that were, well, proceedings on the basis of judgments where the proceedings were instituted before that date, then you will still use the old Brussels I. Okay. Are there any questions at this stage? I don't mind being interrupted if anything is unclear or you disagree. All right. Then let's go on to the material scope. Okay. By this I mean which matters, which kind of cases fall under the regulation. Now, the regulation says quite clearly, all right, civil and commercial matters. That's supposed to be a broad interpretation. The European Court of Justice has granted many judgments on this notion, very broad notion. And the court has given us a few guidelines. First of all, this is an autonomous definition. All right. It's independent of which court in the national system has granted the judgment. Okay. That the court already said, you'll see in the 70s, that it's not relevant to look at the court, but it's relevant to see whether a public authority was acting in its capacity as a public authority, or whether it was acting as a contractual party. Right. Acta iuri imperii are excluded. In the Roofer case, what happened was the Netherlands had the duty to remove a wreck from a waterway. And as a public authority, they administered that. And they could then salvage for their damages. However, in this case, there were still damages that were not compensated. So they wanted to bring a damage claim against the owner of the wreck. The court said, well, if you are acting as a public authority, it is your duty as a public authority to administer the waterways and to remove the wrecks. That's not a civil matter. In the Steenbergen versus Baten case, that was a really interesting case because it was on the border of a civil claim and a social security claim. So the Steenbergen is a municipality, and it had paid out social security to a particular person. The municipality then wanted to reclaim what it had paid out from the person who was liable to pay maintenance. Okay? And the court said, well, if the action is based on maintenance, which is something in civil law, then it falls within the material scope of Brussels I. Now, maintenance has in the meantime been removed from the scope, okay? Because we now have a whole separate maintenance regulation. So you won't find maintenance in Brussels I anymore. But what's interesting about the case is that it tells us, well, look at the basis for the claim. The basis of this claim was the civil liability of the debtor. Similar was the Preservatrice Foncière Triard case. There, it was about a guarantor that was liable jointly for particular duties and taxes, but as an insurer, as a guarantor. Because it was a free undertaking, it was a contractual obligation. Okay, so the court said, well, if you are claiming on that contractual obligation which was freely entered into by this insurer or guarantor, then this is a civil matter. So the fact that behind there was a tax duty or behind there was a social security duty, that's not the issue. The issue is this specific claim, what is the basis of it? Is it a civil duty of contractual law that was freely entered into, or a civil duty of some other nature? Right. The Leturitu case was a case about a massacre of civilians in Greece during the Second World War by German soldiers. Now, is this a civil matter? And here the court said, well, no, this is not a civil matter, right? This is a war, international law, humanitarian law issue. This is not a civil and commercial matter. So that is excluded from the scope. Fly ILL, which you might know, this was a dispute between the Latvian authorities and Air Baltic and Fly Lithuanian Airlines. And the allegation was that Air Baltic and the Latvian airport authorities had abused their dominant position and in this way caused damage to Lithuanian Airlines to the point of pushing it towards insolvency. Here also, the question was whether this was actually public law. And the court said, well, no, because the airport authorities and Air Baltic, when making these contracts, these agreements that were claimed to be an abuse of a dominant position, they were acting in the private capacity. They were not acting as a public authority, right? They were contracting as civil actors. So that is within the scope of Brussels I. So you see, the court has given us a broad notion of civil and commercial matters. Okay, now, to go further on this broad notion, the court has also given a judgment in a matter of private enforcement of competition law. This was the hydrogen peroxide case. CDC was a consortium of damage claims. So it was a group, and it was claiming on the basis of claims it had bought over from the victims, let's say, of anti-competitive behavior. This is a civil claim, okay? The court applied Brussels I to the case. Now, obviously, criminal matters are not civil matters. However, there can be a compensation claim hooked onto a criminal claim, or a criminal court can grant compensation, and that compensation part, that is a civil compensation, is under Brussels I. It's under Brussels I for jurisdiction purposes. Okay, so you'll find in Brussels I that there's a rule to determine the jurisdiction of those courts. It says that if the court is has jurisdiction for the criminal claim, that civil claim can also be hooked onto it. And then the important thing is, of course, it falls under Brussels I bis for the recognition and enforcement. So under Brussels I bis, those claims can also be enforced without any need of exequatur. Okay, in the Real Hemi case, this was a case about patent infringement. And the court issued a prohibition of using a particular intellectual property. Okay, so a prohibition of using the patent, plus costs, right? Plus a fine. Okay, so cannot use this patent. If you use it, then this fine becomes immediately enforceable. Now, who is the fine paid to? To the state. Fine is due to the German state. Now, you can see what happened. The company did not stop the infringement, and the fine became enforceable. And here the court said, well, the basis is a civil claim, right? This is a civil claim. So the fine that is attached to it is also under the ambit of the Brussels I regulation. The fact, the court said, that the fine must be paid to a state, or the way in which it is enforced in German national law, that is of no consequence. This is a civil matter. Now, the regulation explicitly excludes matters of status of persons. Okay, we know, we've heard also that we have different regulations for that. We have a regulation for divorce. We also have a regulation for the parental responsibility. Okay, that's all Brussels II bis regulation. But this exception is phrased in the regulation quite specifically. Okay, it's only phrased as the status of persons, which is interesting if you compare it to the Rome I regulation, where the exception is phrased much broader. There it refers to agreements in family matters. Okay, so the question then becomes, well, what about agreements in family matters? It seems to me that that's a civil matter, right? It also seems to me that that is not excluded under this narrow exclusion. So I'm thinking of situations where people cohabit without marrying, without any form of registered partnership, and they conclude an agreement about their property. Okay, cannot call that matrimonial property because they're not married. Okay, it's pure agreement about their property. When we separate, then the dog is yours and the cat is mine, and you take the table and I take the cupboard. Does that fall under Brussels 1 bis? I think it does. But, yeah, the court has not yet say so, but I do not think that it is under that exception, under the exclusion, sorry. Okay. Then, the matter of arbitration. Arbitration is also explicitly excluded. However, at the very start of the Brussels Convention in 1968, it was simply put, does not apply to arbitration. The first question that arose, of course, was, well, does this mean only the arbitration itself, or also court proceedings dealing with arbitration? Okay, so the court has, in the meantime, had ample opportunity to interpret, has got a lot of criticism from various angles about the extent of this exception. So, the extent of the exception at this stage is that if the court proceedings concern arbitration, that's the subject. Okay, remember, you've always, when you have to look at the material scope, you have to look at the subject. Okay, what is this about? Okay, the subject is arbitration. For instance, the subject is the appointment of an arbitrator, or the subject is ordering the party to cooperate in constituting the arbitral tribunal. That is purely arbitration. That, said the court in the Markerich case, falls outside of the scope. However, the fact that there is an arbitration clause in an agreement does not in and of itself mean that the courts cannot hear the case in any way. That was what the court said in the Van Nuden case. So here there was an arbitration clause. It was clear that there was going to be an arbitration. However, one of the parties became in financial problems because of its liquidity. The claim that it had against the other party was so big that if it had to wait for such a long time to get that money, it would become into severe financial difficulties. So it brought an action in the Netherlands for summary judgment of a temporary payment. Okay, so this is a provisional measure. So the court said, well, what's the subject of the provisional measure? The actual subject of the measure is the payment, not the arbitration. That falls within Brussels 1. The subject is the payment, and then obviously the court also went further to say that this is only provisional, only if the payment can be reversed at a later stage. If there's guarantee that the payment will be able to be reversed, then we can grant this measure. But in any case, that measure is within the scope of Brussels 1. The West Tankers case was the case that made the English arbitration world, and to some extent the French arbitration world, very angry. It was a case where the English court had granted an anti-suit injunction because the parties were subject to arbitration in London. Okay. So the judgment concerned purely arbitration. Okay. It said the parties are not allowed to go to a court in another EU member state because they are subject to arbitration in England. However, the court said, by granting this injunction, you are in fact, as English courts, arrogating yourselves to say that you can determine when other courts can hear the case, and that goes against the idea of mutual trust. So the Court of Justice said this anti-suit injunction to safeguard arbitration proceedings is intolerable in an EU context. Okay. Great controversy ensued. Fortunately, by that time, the legislators were already thinking of the recast. So great debate ensued, and the Commission then, in its green paper, raised various options about arbitration. Okay. In its green paper, it asked the stakeholders, do you think we should leave the arbitration totally outside? Do you think we should include arbitration, make a whole arbitration rule for EU member states? Or do you think we should just regulate that border between arbitration and court cases? That border being when the court has to intervene, when you have to recognize and enforce a judgment that concerns arbitration. And it was this middle ground that came out from the Commission. So the Commission in its proposal chose this middle ground. And it included a few rules on regulating this border area, saying that if, for instance, there is an arbitration agreement for an English court, then the English court will be the court to determine the validity of the arbitration clause, and other courts have to wait to see what the English courts rule on that. However, certain member states, particularly the United Kingdom, France, Hungary, Poland, and I believe Austria, did not agree with this. So in the Council, all these new provisions on arbitration were taken out. And we were left with the original text of the material scope, civil and commercial matters, with the exception of arbitration. However, they did get recital number 12. Now you should go and read recital number 12, because that is a monumental recital. It consists of various sentences and paragraphs to make clear what the ambit of this exclusion is. And it says basically that when it is really about arbitration, like I told you before, then it's excluded but when it is, when the subject is not arbitration, the matter can still fall under Brussels I. That's the ambit of it. However, there is one point at which it is maybe still a little bit unclear, and that is exactly this West Anchor's position, where there is a judgment about arbitration which influences the jurisdiction of the other courts. The Advocate General in the Gazprom case said that that situation would now fall outside the scope of Brussels I bis. I'm not 100% convinced, but that was his argument. The Gazprom case itself, the court did not go into that particular question because that was not the question in Gazprom. What happened in Gazprom was, you may know the case, there were various arbitrations going on at the Stockholm Chamber of Commerce and at the Permanent Court of Arbitration. And then there were also cases at the Lithuanian courts, various cases as well. And the arbitral tribunal at the Stockholm Chamber of Commerce issued an order, and it granted an award. So with the award, an order saying, and the parties should stop certain of these cases that they were pursuing in the Lithuanian courts. Now, the question was to the Lithuanian courts, do we have to recognize and enforce this? The underlying question was, does Brussels I apply to this? All right. Does the Brussels I regulation force us to recognize this judgment or not? And the court was clear in saying this question falls outside the scope of Brussels I. Whether or not you recognize what that arbitral tribunal has said is a matter of the New York Convention. The court referred explicitly to the New York Convention, saying this matter is only for the New York Convention. It's not for Brussels 1. The court referred to the recital number 12, although the case was decided under the old Brussels 1 regulation, not under the new one. The court said, well, this regulation is really an explanation of the law, and it referred to that. It did not go as far as the Advocate General, but in any case, when the order to discontinue proceedings comes from an arbitral tribunal, that's outside the scope of Brussels 1. Right. So arbitral tribunals do not have to comply with this idea of mutual trust. Only courts. Right. That is as far as I have the material scope. Are there any questions at this stage? Yes. Yes, the New Convention of 1958 on the recognition and enforcement of arbitral award. Yes, I should have specified that. Okay. All right. Okay, so the personal scope. Now here you will think I can't count, and you will be correct for thinking so. I got a bit confused with the amount of pillars, but I've decided that there are 4.5 pillars. No, sorry, there used to be 4, there are 5.5 pillars now. Okay. There used to be 4. Now, the court has added, the Brussels 1 bis regulation has added 1. That number 6, I think, should rather be a 5b. Okay, I'll explain what I mean in just a bit. So, the pillars of the personal scope, saying in which cases do we use this House of Brussels 1, okay, and in which cases are we outside of it. This is now assuming, of course, that we are within the geographic, temporal, and material scope. Okay, so let's start with the first 4. Those ones concern jurisdiction. We're going to use those 4 pillars for jurisdiction, and we find the rule in Article 6. This, again, the Commission was much more enthusiastic than the legislation that came out in the end. So what the Commission proposed was, well, let's not work with all these pillars anymore. Let's give this regulation a universal scope. Okay. So let's make this regulation apply to all civil and commercial matters. Never mind where the parties come from, where the goods are situated. We'll create rules for all situations. Okay. The Parliament then said that the time was too early for this broad extension, which is interesting because the maintenance regulation does have such universal scope, as does the succession regulation. But for Brussels 1, it was not accepted. Then the 5th one we will use for enforcement and for parallel proceedings. We find the basis for these pillars in Articles 39 and 29. Then number 5b, if you want, those are parallel proceedings between an EU court and a court in a third state. That's a new rule in Article 33. Okay, but it is only half a pillar, and you'll see why I say so in a bit, because that's not compulsory, while the others are strict rules. Okay. Right, so let's look at our first pillar. First pillar is a very simple one. It is the situation, the location of immovable property. Okay, so if there's a dispute about a building in Paris and the owner has his habitual residence in the US and he is renting it out to a Canadian person who is only using it occasionally, exclusive jurisdiction, place of the situation of the property, regardless of the domicile of the parties. Okay. Now there is a small exclusion for short-term leases, but that's if the parties have their residences in the same member state. So if they live outside of a member state, then that won't apply. So then we will only look at the place of the location of that immovable property. And this is a broad one because it applies to immovable property, but also renting, leasing property, and then also to the registration of immovable property rights, registration of other rights. All the exclusive bases of jurisdiction are within this pillar, saying whenever there's an exclusive basis of jurisdiction, we don't mind where the people live, our courts have jurisdiction. Okay, and Brussels 1 applies. The second one, so the second pillar is forum clauses. If a court within the EU is chosen, then Brussels 1 applies. Brussels 1 will then tell us what are the rules of the formal validity and will determine the jurisdiction. Now, again, regardless of the domicile or the residences of the parties. This rule was a little bit changed. Before, it was required that at least one of the parties have residence or domicile within the EU. That is now changed. Okay, the pillar is merely a court within the EU is chosen. Now, what if a court outside the EU is chosen? Well, that's not part of the pillar, okay? If a court outside the EU is chosen, we don't actually mind. We're going to look at the next pillars. Okay, so we're going to look at pillars 3 or 4. The Taser International case is a case of 16 March of this year, and this was about a dispute between a third country national from the US and a party within the EU. It was about the transfer of trademarks and a non-exclusive distribution agreement. There was a choice for the non-EU court, but in the EU court, there was a voluntary appearance. Okay, so that means, in fact, a tacit renouncement of this forum clause. All right, the party is not raising the forum clause. The court said that the national court does not have to take into account this forum clause if it's not particularly raised. The fact that there's a forum choice, the fact that there's a forum choice for a third state, that does not change anything really as to the scope of Brussels 1. So the scope of Brussels 1 is in this case determined by pillar number 4, which we'll come to, which is the residence or the domicile of the defendant. Okay, and if the defendant then voluntarily appears, then there is jurisdiction. Note, however, that voluntary appearance is not one of the pillars. The pillars are forum clauses or domicile of the defendant. That is because Article 6 does not refer to voluntary appearance. Now, this means that if a defendant is resident in the EU, but there is a forum choice for a country outside the EU, it's the Brussels 1 scope that would apply. Okay, so you would apply your jurisdiction rules under Brussels 1. Many national systems have a mechanism to refuse jurisdiction because there is a forum clause for a third state. You cannot use that refusal basis in national law. Okay. You have to take jurisdiction because that's what the court said in the Owusu case. The residence of the defendant gives compulsory jurisdiction under Brussels 1. This was not an oversight, unfortunately, by the negotiators of the Brussels 1 bis regulation. This was a deliberate choice because they said, if other countries want us to recognize and enforce forum clauses for their courts, well, they should sign up to the Hague Choice of Court Convention. Okay? So, Mexico did that. It's the only state, apart from the EU member states, that have ratified the convention. Singapore has signed, and I'm told will soon ratify that convention. So, if there's a choice of court for the Mexican courts, then we are all as European Union countries bound by that convention, so we'll recognize it. If there's a choice of court for the Turkish, a choice of court agreement for the Turkish courts, we'll just ignore it. If the Brussels I regulation applies on the basis of one of these 4 jurisdiction pillars, right? So let's get then to the 3rd pillar, which is a new one. This one is new. It says that if the consumer or an employee is domiciled in the EU, then the regulation applies, regardless of the domicile of the defendant. Okay, so this is an extra protection for EU weaker parties, employees and consumers. If a consumer buys something from a company in a 3rd state, the consumer can sue in his or her national court if he or she falls within the protective categories. So Brussels I applies to that case. This, in fact, is one of the only remnants of those very ambitious plans of the Commission. Right? The Commission wanted to extend to a universal scope, but this is all that was left of those ambitious plans. The 4th pillar is also one that we used to have. So the 4th pillar is the domicile of the defendant. Okay, so there's no exclusive jurisdiction, there's no forum clause for an EU court, there is no consumer or employee. Then all other cases, we will look at the place of the domicile of the defendant. If that is in the EU, then the regulation applies, regardless of the domicile of the plaintiff. That the court made very clear in the Group Josie case, where the plaintiff was from Canada and the defendant was from Belgium. Then, if none of these 4 pillars applies, then you would fall back on your domestic basis of jurisdiction. Now, this is what is the controversial part, okay, because it is totally skewed if you look from a 3rd country perspective. So, if none of these 4 pillars apply, for instance, you have a defendant that is domiciled in a 3rd country, then you can fall back on the national exorbitant basis of jurisdiction, such as the nationality of the plaintiff, the location of movable property of very limited value. However, the resulting judgment will be an EU judgment, and you'll fall within the 5th pillar when it comes to recognition and enforcement. So for 3rd country nationals, this is a very skewed way of working. Okay, but that is what the Brussels I bis regulation says. Brings us to the 5th pillar, which is the pillar that we use for recognition and enforcement. That's very easy. Okay, that is, see where the judgment is from. What are we recognizing or enforcing? Well, it's judgment from an EU court. It's emanating from an EU court. Fine, we use Brussels I. Very easy. If the judgment is from outside the EU, Brussels I doesn't apply. It's national law that will apply. The same applies to parallel proceedings. If there are parallel proceedings between 2 EU courts, we'll apply the regulation. If there are parallel proceedings between an EU court and a 3rd state court, we have a specific rule. That's my rule number 5B. This one. This is also new in the recast. Okay. Previously, there was no way of refusing jurisdiction once the jurisdiction was established under Brussels I. Now, we have a new rule that there is a possibility of declining jurisdiction. However, only if the basis of jurisdiction, the general or specific basis of jurisdiction were used, such as the domicile of the defendant or the place of contracting, if one of those bases were used. Obviously not if there were a forum clause but also not if they were exclusive basis of jurisdiction or voluntary appearance. Then you can't use this. You can also only use it if the third country court was first. Okay. Remember, the English have a way of declining jurisdiction no matter which court was first, but in the Brussels I regulation, it's only if the first court was the third state court. Then it's discretionary. That's why I'm so much doubting to call it really a self-standing independent pillar, because it's just a possibility. So Brussels I still applies, but there is a possibility to decline jurisdiction in favor of a court in a third state. Okay. Because, of course, here the issue is not so much mutual trust. This is comity, it is respect, but it's not mutual trust. It's not within a closed circle that we know that we will have reciprocal rules. Then, having looked at all the pillars, the last issue is the relationship with other instruments. Various parallel instruments can come to mind. The first is EU legislation on specific matters. They take precedence according to Article 67. Specific conventions on particular matters as well. We're thinking here of the CMR Convention, which is a convention on road transport. That would take precedence over Brussels I for matters not covered. For matters that might fall within both. Then the CMR Convention will take precedence. And then, of course, bilateral treaties. Now, there are many old bilateral treaties that were concluded since the 1800s when states recognized the importance of the enforcement of foreign judgment, this reciprocal enforcement of foreign judgments. Now, all of those bilateral treaties have become subject to Brussels I. Brussels I takes precedence over them. But of course, they can still apply to matters for which we don't have EU legislation, such as, at this stage, matrimonial property. Okay, those we can still use the bilateral treaties. Now, then I have said that in order to see which bilateral treaties there are, so if you see, well, we're outside of the scope of Brussels I, maybe there is a bilateral treaty that we can use. They're all on the e-Justice portal. Now, I inserted a link there, but it's not necessary to show that to you because you have seen all of that by the previous speaker. Yeah, that was the bilateral treaties. Then three other treaties. The Lugano Convention. Okay, so here you would first look at your pillars under Brussels I, but then you will see that the Lugano Convention can interfere. For instance, there is a choice of court agreement for a court in Switzerland. Then obviously that will interfere with the scope of Brussels I. Then we will give respect to that choice of court agreement. The same if the defendant is resident in a Lugano state, Switzerland, Norway, or Iceland, then we will give precedence to the Lugano Convention. Article 73 explicitly also states that the new, and here I did insert the proper reference, the New York Arbitration Convention of 1958 is not affected. Okay, this is to actually echo this recital number 12, and also, of course, to echo the case law of the Court of Justice, that arbitration is outside of the scope. Although, as I've shown you, there is still some friction on the dividing line. The Hague Choice of Court Convention applies if one of the parties is resident in a non-EU state. Now, this rule you'll find in the Hague Choice of Court Convention in Article 26. It is very difficultly formulated, but it actually boils down to saying that if one of the parties is resident outside the EU, but in a contracting state, then we will take that convention. All right, then existing bilateral treaties are not affected. I have actually already referred to bilateral treaties. That is all that I have for you. Are there any questions? Yes.
One question. I would like to know exactly, because Denmark doesn't take part in this regulation according to your information, according to the text.
Yes.
But the problem is, in this case, in this particular case, we have to apply the agreement entered into between the community in Denmark, which is the scope of this agreement. Because I don't know exactly, this agreement deals with most of these issues which are laid down in this regulation, the regulation we are talking about.
Yes, yes. So the agreement is actually quite short. Okay, the agreement says that this regulation applies to, or the rules of this regulation applies in Denmark. Okay, so we're going to use exactly the same rules for Denmark. So the agreement doesn't take over all the rules, it just refers. And then the agreement says something about the jurisdiction of the Court of Justice. So in fact, all these rules on scope, you can apply them in the same way for Denmark.
Yes, but do you think that according to, I don't see too much logic in this idea and this philosophy of doesn't take part in the application of the regulation at the same time entering into an agreement with the European Union. I don't see any logic in it.
Yeah, well, that's a political question, but I will do my best. At the moment when this was negotiated, which was at the Treaty of Amsterdam in 1998, there was one chapter on civil, criminal, and asylum, and that's obviously the touchy issue. Okay, so that's a practical. Yeah. Yes, because they even had a referendum to take it out, and they decided not to. So it is because they don't want to give that part of their sovereignty to the EU. Yes, but for this, that's not a political issue, so they want to join, so they're welcome. Yeah. Yeah.
A question on the same issue, the application towards Denmark. I got stuck with the problem recently, whether or not the recast is applicable. You mentioned this notification, and the information available to me said, well, the notification itself may not be enough, because there need to be some kind of ratification by the Danish Parliament. In the end, it didn't matter, but I'm still not sure whether the recast is applicable at this moment or it is not.
Well, the original agreement says that whenever there's a recast, Denmark can, by way of simple notification, notify the Commission of its intention to take part, which Denmark did. Now, if Denmark didn't follow its internal procedure, I'm afraid I'm not aware of that.
Me neither. I couldn't find any Danish.
Yeah, I assume that if they gave their notice to the Commission that they followed their internal proceedings, but...
So you'd say it's perfectly applicable?
Well, yes, I would think so, yeah. There's another one, yeah.
Going back to the scope and exclusions about insolvency proceedings.
Insolvency,
what about this kind of proceedings in connection with the insolvency? I mean, I remember, I think, under Article 6 of the new insolvency regulation recast, rules that these proceedings in connection with insolvency proceedings are under insolvency in regulation. And how it will work with this regulation. Because the exclusion here is only the insolvency proceeding.
Yes. Yeah. The idea is obviously that the Brussels I regulation and the insolvency regulation fit together seamlessly, right? That they are, that the one starts where the other one stops. Now, for issues that are excluded on the basis of the merit of the substance, such as insurance contracts, I think that they do not fall under Brussels I because they're still insolvency, and there are specific specific insurance regulations in the EU on those instruments. So if they are taken out of the scope of the insolvency regulation, they are still insolvency matter-wise. So to my mind, they do not fall under Brussels I. Yeah. I know. Do you agree with that? Yeah. I think.
Well, my idea would be that you, as a specific regulation, insolvency, you would have to look at its scope, and that everything that falls under the scope of insolvency automatically falls outside of the scope of Brussels I.
Yeah.
That would be my, yeah.
Yeah, but if some of the insolvency matters are excluded from insolvency regulation, but then I think they can't come back into Brussels I because matter-wise insolvency is excluded. So I think they're only under the specific rules. They're not under Brussels I. That would be my interpretation. Other questions?
All these regulations are very interrelated. So it means that in some points there is a kind of, in some provision refer to the convention, to the regulation 44. So it means that maybe we have to read carefully, the content of the provision, or maybe, some provision can be applied perfectly.
Yeah.
It's a question of each study, so it's not,
Yeah.
the answer is at all.
But I do think that there will be more case law on this issue of insolvency because the insolvency regulation scope is extended quite broadly to recovery. Okay, so the question then is, will the broader definition of what insolvency is also apply back to the Brussels I regulations exception on insolvency? And I think yes, I think that there should be an EU autonomous definition of what do we understand under insolvency proceedings. So if something is insolvency, it's out, even though this definition has now broadened. But that's, I mean, that is my opinion. I do think that the court will get questions of that nature.